What the pandemic has told us is that life is too short, and many clients are feeling like that in their relationships also. I've spoken to many clients recently who are in strained marriages, and they've realised that it is no longer what they want. However, they've often stayed together because of the family unit, as there's young children, or because there are finances to deal with and there's just simply not enough money to go round. Lots of people are in that situation. The pandemic, of course, has meant that people have had to spend significant periods together that they previously did not do because they were out to work, attended various different activities and clubs. But the pandemic has forced couples to spend more time together than they normally would. In April 2022, the new no-fault divorce legislation is being implemented. This means that for those couples that have been in strained marriages or no longer feel that the marriage is what they want, they can divorce without either having to apportion the blame or wait a minimum period of 2 years. It means that the whole divorce process should run a lot more smoothly and also be less emotionally draining for clients. When one party is citing unreasonable behaviour, it's never very nice for the other party to read what is being said. But often people are using that ground at the moment in order to get the divorce to go through quicker than having to wait for a period of 2 years. Under the new legislation, it means that parties can make a joint application for divorce, which is a significant change. It does also mean that one party can still make a sole application if the other party does not agree. The language is also being updated, so what was previously decree nisi will now become conditional order, and decree absolute will become final order. There will be a period, a minimum period of 20 weeks between issuing proceedings and applying for the conditional order. And this is in order to allow the parties a period of reflection to ensure that divorce is truly what they want. The other positive with the new legislation is that many clients are concerned about the impact for example, an unreasonable behaviour petition would have on children. I've had cases before where, for example, the wife is concerned that if a petition has been issued based upon her unreasonable behaviour, that the husband will show it to the children in the future. That should never, of course, be the case, but unfortunately it does happen. It means that by not having the blame pointed, the parties can focus their energies on resolving any disputes about the children and also dealing with the division of finances. Mental health has been a significant issue over the last 2 years during the course of the pandemic, and people realise that they don't want their mental health to suffer by dealing with emotionally draining divorce proceedings. They just simply want to be able to be free, move on with their lives and be as amicable as possible for the sake of the children and also to resolve matters swiftly without any unnecessary hostility. Many clients are still asking whether they need lawyers. The short answer is yes. Of course, there are an increasing number of clients that are dealing with the divorce process themselves due to the implementation of the court portal, which has made things run a lot more smoothly. But lawyers are still required. For example, if there are any issues with the children and how much time they should spend with either parent, or if parties need some assistance in dealing with financial matters. So it may well be that lawyers need to draft documents or assist with negotiations. Instructing solicitors should not be seen as a hostile step, but there is still a need, particularly with financial matters, for there to be fairness, and sometimes parties need a little advice on what is fair when it comes to the division of financial matters, rather than being pressured by one party.